Welcome to Law and Society, where legal and social issues come together. With Andrew Stevenson, attorney at law. Andrew, welcome back.
Hi, Mark. Nice to be here.
Good to see you again. And I'll tell you what, each one of these shows we do, I learn, and I know our listeners are learning about the law, their rights, what to do, what not to do. Mm-hmm. Today is a great topic. And part of this is again, I want to kind of just briefly review your mission and what you're trying to accomplish, which is basically to educate people, to keep people from making dumb mistakes when it comes to the law.
In a lot of different ways, yes. As I've said before, I've been working through my top 10 list of things you can do to get yourself in jail. And today's topic is kind of in honor of the 4th of July and the nomination of the new Supreme Court Justice, and it has to do with the Fourth Amendment.
Okay.
And I found a lot of people just don't understand what their rights are when it comes to searches.
All right. And the Fourth Amendment, you say to the Fourth Amendment to most people, that's not one of the ones they generally remember. They remember
number one.
Yeah, that's your right of free speech,
and they remember the right to bear arms.
Right. That's the second.
The Fourth Amendment deals with warrants and searches.
Okay.
Of people, their homes, their cars, their phones, things along those lines.
Okay. And again, that's where people get really confused is what they're allowed, what is a search warrant, all that. So we're going to kind of get into that today. Can I read the Fourth Amendment?
Sure, please do.
Because you did such a great job. This is actually what the Constitution says. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause supported by oath and affirmation, and particularly describing the place to be searched and the persons or things to be seized.
Right.
That's pretty darn specific, isn't it?
It's very specific. And what it's intended to do is to balance the needs of law enforcement and the government. Mm-hmm. They have a job to do. We need them to do their job. I want them to do their job. But we give them an enormous amount of power.
Right.
The police have the right to arrest, detain, enter people's homes, invade their privacy. So there's a balancing act between what the law enforcement community needs to do their job and what citizens, what right of privacy do we have from intrusion from the government. Right. And that's what this Fourth Amendment was intended to do, which is balance those.
Well, let's start with what is a search warrant then. First of all, let me pose the question. What is a search warrant, and how do the police get them?
A search warrant is a legal right to conduct a search, generally for evidence. Mm-hmm. To get a search warrant, an officer has to sign an affidavit or a sworn testimony to certain facts. They present this to a judge and say, Judge, I think I have enough evidence or probable cause to search this person's home, to take their blood, to search their car. And if the judge agrees that there is sufficient evidence, then he will sign the warrant. The warrant is a piece of paper that says to law enforcement, they may enter this house within this time period to look for these things and take them if they find it.
And it is a specific thing or things they're looking for, right?
It's supposed to be very specific, but most search warrants are very broad. They list every conceivable thing you can imagine you could take out of a house, including computers, financial information, tangible objects, any instrumentality of a crime, whatever that may be.
Can be used or useful in the commission of a crime?
Correct. So it's pretty broad. They can't take the refrigerator unless it had something to do with the crime, but they can go through just about everything else.
Interesting. So when they're written, they're generally written to be so that if I am looking for drugs but I find an illegal firearm, I can seize the firearm?
Yes. It's called the plain sight rule, which if the police are legally somewhere they're allowed to be, such as in a home, and they happen to uncover other evidence, such as a body in the basement or a sawed-off shotgun, yes, they're allowed to seize that as well.
And this has been a lot of the Supreme Court has, over the years, they've defined what is the home, if you will. Is it the trash cans outside the home? Those types of things.
There have been many cases. This is probably one of the most litigated areas in the law is the Fourth Amendment. What can be searched under what circumstances. The home is considered the home as well as the curtilage. Mm-hmm. The curtilage is a fancy word for saying the immediate surroundings, the front porch, the attached garage. Now, if you have a barn that's way in the back, that may not be considered curtilage.
Okay.
But the inside the fence, things along those lines.
So the police definitely, if it's a rural property, need to know what the boundaries
the
would
warrant
be.
should generally say outbuildings, things along those lines is how they cover it.
So that's the preferred method, and that's what the Fourth Amendment says is under those circumstances you go to the judge. And again, you think of judges as being in the courtroom only during the day, but this is something they'll do after hours, right?
They will get calls at home. There's usually a judge on duty,
Gotcha.
and if it's 3 o'clock in the morning and they need to take blood from somebody because of a fatality, and the person doesn't consent, they will go and knock on the judge's door at 3 in the morning and wake them up.
Yep.
It's one of the little things judges do that people are not aware. In fact, in the courtrooms, quite frequently, police officers come to court during the day to get warrants, and they go back in the judge's chambers.
Wow. There are instances, though, where a search can be done without a warrant.
There are, and there's numerous instances of that. Generally, there are maybe 4 or 5 situations in which a search can be done without a warrant. I
remember one here in our area, and I won't name the names, but it was a young girl that was kidnapped and imminent danger of her dying, and they basically busted into the house and searched it without a warrant.
That's number one is emergency. If they believe that there's a justified emergency to do this. Now, this comes into play quite frequently with acts of terrorism. If they suspect that there's an act of terrorism that's going to be happening, they will exercise that right and skip the warrant, and then that gets litigated later. Another one is what's a very common one is called a search incident to an arrest, which is basically once you are placed under arrest, law enforcement then has the right to search you and the immediate surroundings in which you were found.
So if you're at home...
If you're at home, they can search, let's say, the living room or the kitchen where they found you. Now, going down to the basement and opening the closet is a no-no, but they can search the immediate area. If you're pulled over in your car and you're arrested for drunk driving, or you're arrested because you don't have a license, that then gives them the right to search the entire car.
Once they place you under arrest and read you your rights,
right?
Then that search kicks in.
That kicks in. They can also then do an inventory search when they tow your vehicle, which they do.
Okay.
I've had a couple of cases where someone got arrested. They towed the vehicle when they were going through it. They then found something which led to charges.
The inventory search is if they tow your vehicle to make sure that you don't claim that something was taken later.
That's
and
what
that kind of thing.
That's what they do, but that's
the premise of it.
That's the premise, and they do it. They do take an inventory of the vehicle, the CDs, the purses, the tools, whatever it is that's in the vehicle for safekeeping, and to make sure that it's still there.
I think one of the biggest gray areas in all of this is that term probable cause.
It is.
And give us your experience on that in terms of, it seems like a pretty broad brush to say, I had probable cause to search the home or the car or whatever.
Probable cause is a phrase which basically means a reasonable basis or belief that there's evidence of a crime or that a crime has been committed. The law loves words like reasonable. We're supposed to be free from unreasonable search and seizure. That's what the Fourth Amendment says. So probable cause is kind of what people would think of more in terms of how much evidence do you have. If someone is walking down the street at 3 o'clock in the afternoon and they happen to stop in front of a jewelry store and they're looking through the window, and the police were to come up to them and say, "Hey, I think you're about ready to rob this place, and I'm going to search you," most people would say that's not probable cause.
Yeah.
On the other hand, if it's 3 in the morning and you've got a hoodie on and you have what appears to be a bag with you and maybe a hammer sticking out of the bag, and you're looking in the window of the jewelry store, and the officer comes up and says, "Can I search your bag?" And the person says no. He may at that point then have enough evidence to suspect that there's a crime afoot.
Okay, this is the slippery slope now, because here we are. You're saying, I've got a hammer in my bag, and it's 3 in the morning, and I'm standing in front of a jewelry store or whatever. Now, when does that ordinary hammer... I just fixed Mrs. Johnson's door jamb over here. She called me, and I had to get it fixed because she couldn't lock her door, so I came over with my hammer and fixed it. At what point does that ordinary hammer become a criminal tool? Where's that problem? That's
why we have courtrooms and lawyers. That's the type of case that gets argued in a courtroom. That's the type of situation where where people go to court and the officer has to get on the stand and the officer has to say what his belief was, what his reasoning was.
Right.
And the job of the defense attorney is to point these things out, that maybe they violated it. The problem is that you're usually never in the courtroom unless the officer was right. That's the problem. That's where they have a bit of an upper hand in that, well, obviously I was correct because I found the map to the back of the jewelry store in the bottom of the bag, which showed what the combination was to the safe.
There are, right.
Yeah.
Exactly. But the far more gray area is going to be searching your vehicle. You get pulled over.
That's correct. And that is probably the most common searches that are done.
And probable cause there can really stretch the boundaries at times.
It does. And it is a very thin line. Now, the Supreme Court over the years has said that basically a person's expectation to privacy with respect to their vehicle is pretty darn low.
Well, yeah, especially in our era of traffic cameras everywhere and everything.
Well, it's that, and it's you're out in the public, you're out and about in public. Now,
using a public roadway.
Using a public roadway in a licensed vehicle by the state, where the state pays for the roads and gives you a license to drive. However, your right to privacy in your home and your body is the highest.
Okay.
So we find that one of the bigger fights is blood draws. Is there really sufficient evidence to get a warrant? Now, in DUI stops, generally there is. Generally, the officer says he failed the field sobriety test, and they smell of alcohol, and there's a six-pack on the front seat. So the judges will sign in that instance.
And hence the reason I want every officer to have a body camera so that those things are indisputable in terms of failing the field sobriety test, that type of thing.
But the basic rule is if they pull you over and they want to search your vehicle and you say no.
Which you're allowed to say.
Which you're allowed to say, and I'll cover that after the break. But the police officer has three choices. Number one is the officer can go ahead and not search, honor your request, honor your exercising of your constitutional rights. Number two, he can go get a warrant. Or number three, they can go ahead and search it anyways and sort it out later in court.
As in, I saw something that it triggered me to think I had with probable cause.
Correct.
So very, very liberal interpretation here of that.
Right, and it's up to the officer to make that decision.
And again, you said before we went on, I said, well, if I get pulled over, I've literally never been asked to search, and I've been pulled over for a couple of speeding ticket here or there. They've never
probably not going to ask.
They
search
don't.
your car.
I guess I don't look like a drug dealer.
No, you don't.
So I think most people who think they're going to get pulled over and searched, they probably don't have anything to worry about.
Correct.
All right, this is great. Again, it's very interesting to me that you can say no and they can search anyway.
They can. I mean, but is it a legal search is what the question becomes, and that's where the lawyers and the judges get involved.
Right. Now, when we come back, we're going to talk about consent, and then the whole thing about, may I search your car? Why, yes, go right ahead. We'll get into that in just a couple of minutes. You're listening to Law and Society. It's where legal and social issues come together. Andrew Stevenson, StevensonCriminalDefense.com. If you'd like more information to listen to this show as a podcast, or also if you find yourself in trouble, give Andrew a call. We'll be back.